Today, I'm going to talk about to probate or not to probate. What does probate mean and when is it necessary? So the reason for probating a person's estate is that they have passed away and they own assets such as real estate or bank accounts that need to be transferred to other people who they have left behind. And if the person who has passed away, we will call them the decedent. If they have left a will, they have left clear and concise instructions on whom they want their property to go to and who they want to represent them and execute their wishes, that is, the executor of their estate. So if there are assets that need to be transferred, the person who has been nominated as executor needs to apply to a court in the jurisdiction where the decedent lived for appointment as executor and to receive something called letters testamentary. Once they are appointed by the court, they will receive these letters, which then give them legal authority to transfer and collect and receive the decedent's assets, and thereby to honor the decedent's wishes that he left in his will as to who is going to get which portion of those assets. It's a fairly simple process, although it does involve one court hearing and a couple of documents and filings and inventory, things like that, just to keep everything transparent for the heirs and the beneficiaries of the decedent. Now, if there isn't a will, if the decedent did not leave a will, then the process is a little bit more complicated. So what we call that is an administration and heirship. Someone must apply to the court to be appointed administrator of the decedent's estate, to collect their assets, to pay their debts, and to distribute their property. There is no one named by the decedent because there isn't a will, so usually it is a close family member who applies for the administration. But before the administrator can be appointed, the court must make an heirship determination, must determine who are all of the legal heirs of the decedent and what proportion of the estate are they entitled to. They may not be equally entitled to a per capita distribution. There may be heirs that are a little bit farther related from the decedent. So once the court determines this, then the administrator can be appointed and can distribute the net assets to these court-named heirs. So this does not take into account the decedent's wishes as to who is going to be in charge and as to who is going to receive what portion of the assets, and it is a little bit more controlled by the court. Several more things have to happen, including the appointment of an attorney ad litem to represent the interests of the heirs and particularly the unknown heirs, because since the decedent has not left a will naming his beneficiaries, then the law has to decide who all the heirs are, and if someone has not come forward, the attorney ad litem has to investigate and report to the court who all of the heirs are. So it does take a little more time, a little more expense, and a little more uncertainty as to who those assets are going to go to when the decedent has passed away and when his estate is finally administered. So it is very important to have a will, but it's also very important that if a loved one has passed away without a will, that you retain an experienced and knowledgeable probate attorney to help guide you through the process of probating your loved one's estate. And an attorney can help you do that in an objective but yet compassionate manner to help you get through one of the worst periods of your life with a little more dignity and a little more peace of mind. So please contact an estate planning or probate attorney for more questions about this issue. My name is Margie, and I will see you next time.